the state court judge that Donald Trump's weaponized DOJ targeted, arrested, and is now prosecuting for obstruction she was a judge from Wisconsin. She's fighting back. She has filed a motion to dismiss the indictment on the grounds of immunity. I wanted to cover this with you, Harry Litman, because we had previewed this a few weeks back, or maybe a month ago or so, although the space-time continuing under this fascist Trump regime bends and contorts. But, one of the things that we said is, look, this was a judge who was going through a docket that involved criminal charges against people in state court. And she was going through her docket, enforcing the laws of the state. And during her court proceedings, not, and not like after, not before. This wasn't like coordinated in a way that you would normally deal with this. Because if you wanted to go and arrest the guy, what you do? It's very easy. You send a message to judicial services. They have somebody who responds on behalf of all of the judges. You say, hey, we have this situation. The judge gets messaged. You coordinate it back. You send a letter back. Sure, at this time, this person will be in there. We will inform the person in the courtroom that ICE is waiting, whatever the resolution is. But they went in there to provoke. They did provoke. They then arrested. And now she's saying judicial immunity. Let's talk about that. When the scope and confines of judicial immunity, the Trump regime is going to argue outside the course and scope of her judicial duties. Any intentional criminal act is inherently outside of judicial immunity. But she's going to argue it wasn't outside the scope. I was in my courtroom, literally going through my docket. You created a danger to my ability to deal with the person before me. So it's an interesting state v. federal issue that we should get in the weeds on. It's why people come to us here, Harry.
Okay, yeah, and it's a really interesting point because it kind of tracks what they're saying in the actual case, what the feds are saying and what Dugan is saying. So look, I'm doing my job here. My job is presiding over my courtroom. I have immunity, and that's solid. It's existed since before the Constitution. Congress can't change it. And that's all true. And what the government will probably try to say is, yes, you have immunity for all the going through your docket. But at that moment that you did something a little funky that they're saying, which is try to escort him out the door to elude arrest, or so they're claiming, then you don't have immunity. A really interesting and important point about immunity, Ben, you can't question the subjective intent of the person who has it. So it becomes irrelevant what she's doing. And if she's acting in her official capacity, saying, Mr. Ruiz, here's the door, there's a factual dispute whether she did something like that, or one deputy says he saw her escort him. But it doesn't matter why she's doing it, so long as she's doing her normal job. And she frames this in a broader way, saying, well, here I am trying to run my courtroom. The feds come in trying to make a commotion. You are really weeding in my garden. And the question's going to be how to define that garden. Now, this is a motion to dismiss, as you say, so it doesn't even go to the facts yet. The U.S. is claiming there are a couple little real important differences between what's in the complaint and what she says happened. I think this case is going to go to trial if it's not dismissed, and we can air it out then. But this, she's saying, look, we don't have to get into the evidence at all. Here I am sitting, in my courtroom presiding. You guys can't come in and mess things up. I get to decide how I handle a docket, who goes out where, etc. That's not for the feds to tell me what to do. And if that prevails in this first instance, it's a free, the complaint is out, any prosecution is out, and also, as I say, we don't care what's in her brain about it at the time. So it's a pretty substantial motion. Defendants all the time raise motions to dismiss, but this one is weighty, and we'll see what the federal court in Wisconsin does with it.
You and I have both taught law at different law schools at different times. And the idea of everything that we taught in a constitutional law setting really kind of being upended by this Trump regime and this current Supreme Court and all of these cases that are, testing is such a mild word here, imploding, skewering the common conceptions of what we thought the Constitution, meant. I mean, where we're going to be teaching about, can you take people in the United States and throw them into concentration camps in foreign countries, and then you bring them back and then you charge them based on something that happened in 2022. I'm talking about Abrego Garcia.
Right.
All of these things that are the unthinkable. I think this was all opened up by the absolute immunity ruling that the Supreme Court gave, because there's no fear of repercussions if it doesn't go your way. Hey, I tried. But I just think about, Harry, Abrego Garcia. I think about this case. I think about the case of David Huerta, the union leader, who looked like he just got thrown to the ground.
Yeah.
And so just to talk about that, Harry, just as a constitutional scholar.
Yeah, I mean, here's what's basically going on in these different cases, man. They're coming in, are the feds, and they assert immunity all the time. They assert law enforcement power all the time. Remember, we've got a system of federalism with joint sovereigns in state and federal law. So what you're seeing really in LA is Newsom saying, yo, we're sovereigns too. You can't just steamroll on us. Judge Dugan, hey, I'm a judge. I have immunity the same as you've been claiming you have, Mr. President. And we are seeing, and it's in these other migrant cases as well. How dare you interfere? What do you mean, how dare you interfere? How dare you, feds, come in and try to make us do stuff and commandeer us? How dare you take advantage of our courthouse, which they do, coming in because they know people have gone through magnetometers. So I think from the sort of individual cases where they're going after, say, deportees and the like, we're moving to a class of cases which really present pretty stark clashes between federal and state power. And supposedly, the conservative members of the court over the last 20, 30 years have endorsed a number of doctrines that really give muscle to the claims that states are equal sovereigns and you can't just push them around. And some of those are now going to come to the fore as states like California and others are going to push back against what's going on and asserting their own sovereign authority, their own sovereign immunity, and saying it's the feds who are weeding in their garden.
I always said, though, that I always thought all of these right-wing frameworks were basically just tools of sociopaths. And, it's like heads I win, tails you lose. And I think about the way like a little kid tries to always make the argument about why, to their parent, or come up with whatever the latest excuses why they shouldn't be held accountable. And I think about that in terms of all of these sometimes conflicting, but framed in intellectual ways, these frameworks by the right wing. Oh, we are for states' rights. Okay, well, you're for states' rights. Well, then what about states' rights when it comes to, issues like we're seeing right now? Oh, no, then we need a unitary executive. We're for the unitary executive. There's a term, go back and have you read the Federalist Papers? Well, that's the same argument you were making, but that doesn't make unitary is a big word. We're strict constructionists. We're strict textualists. So you're a strict textualist. But what about that Second Amendment that says well-regulated and says militia before you get to the comma, and then it talks about the right to bear arms? The comma eliminates all the other words. Everybody knows the comma. You don't read before the comma. So what are you saying? We're originalists. What do you mean? You just go back and see what the founder said. Well, they didn't even have these guns then. Well, if they did, they surely would support. And so it's like, that's why I say the frameworks were done in a way to try to win the argument before the argument was even had. And now that you have someone like, Trump, kind of a raw, unadulterated Mussolini style dictator, they're just like, whatever, it doesn't make a fucking difference. It doesn't make a difference, whatever.
Well, I mean, and that's exactly the worry, right? I mean, we had these situations where then the federal government was the big bad federal government, and we wanted states to be able to push back in all kinds of ways. Now, this is coming up especially in LA, but across the board, including this theme in the Dugan case. Who's really got the final drop? Who can really, what you're going to hear, we've heard it again and again, and will the courts endorse it, say, in these two situations? Hey, at the end of the day, what we say goes, and by what we say goes, I mean how we interpret things. Is it a rebellion? Is it immunity? Is it insurrection? You've got to listen to us. And why? The argument, I think, that we're seeing again and again, because it's an emergency. If you don't, and now I'm Mr. Emergency and come to the rescue. That is going to be a recurrent theme. We saw the Supreme Court push back in the context of interpreting the Alien Enemies Act. We'll see if they do when it comes to state immunity. We'll see if they do when it comes to Title 10 and federalizing the National Guard. We'll see if they do if Trump invokes the Insurrection Act. But we are really, I think, gravitating, Ben, toward clashes between really fundamental state and federal power. And yeah, this is a court that's talked pretty nice about, or pretty enthusiastically about state power over the last 20 years. And we'll see if that theme holds, or if whether in these circumstances, whatever they may be, the executive gets the final call. And then if they do, it sure starts to look like we're in an authoritarian society with a president calling the shots.
Well, they sure talked about it originating with Clinton. We saw a lot of it in Obama. Yeah. And a lot of unitary executive stuff all of a sudden starts percolating with George W. Bush. We start seeing that, and so, yeah, I mean, it's really dictator power versus our Constitution at this point. Is the paper that it's written on worth anything at all? Or is it literally just raw, unadulterated Putin, Kim Jong-un, the court's a rubber stamp, and Congress is a fiction, at which point the next move Trump makes is getting rid of the midterm elections and then declaring himself dictator for life. That's not hyperbole. That's coming, depending on what happens over the next few months.
Or it's possible. And then, I don't know, Ben, maybe we should look in Portugal, or we'll have to then figure out where we go into exile, right, if we don't live in a democracy anymore.
Well, don't can't let them know in advance where we're going.
Very good point.
Not Portugal.
Right, exactly.
I'm going nowhere. I'm staying here.
I'm sticking around here too. We're fighting to the end.
In LA, they're going to have to rip
the microphone to the end.
Everybody go check out Harry Litman's Substack, the Talking Feds Substack. Check out his YouTube channel, the Talking Feds YouTube channel. And then also check out his podcast, the Talking Feds Podcast. That's where I get my news from. Thanks, Harry.
Thanks, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.